Machine Rental and others, and the Matter of System Rental and others, and Mineral Resources Limited, PTY Limited and others for judgment.
May it please the court, Justice Majid, I appear for the first applicant in 66 and the first respondent is in 67 in the round set. There's the court please.
Just give us your name for the record.
I apologize, Justice. I am Kenny Kure from Johannesburg Society of Advocates. Thank you so much.
My name is Larry Hawthorne, for the respondents in case 66/21 and the appendix in 67/21. Give us that.
My name is Advocate Sani, I'm with Johannesburg Bar. I haven't taken the pleasure of appearing before this first time. So I take the liberty to introduce myself. I am here for the American Magistrate and the Center for Practical Studies and the Lawyers for Human Rights.
Today, this court acts on judgment in two applications for leave to appeal against the judgment and order of the High Court of South Africa, Western Cape Division. The underlying proceedings in the High Court concern the alleged defamation of two mining companies and their office bearers by a group of environmental activists and lawyers. The mining companies are Mineral Sands Resources Pty Limited and Mineral Commodities Limited, joined in these proceedings by two of their office bearers, Mr. Zamele Tunia and Mr. Mark Victor Caruso. In the interests of brevity, these parties are collectively referred to as the mining companies. The environmental activists are Ms. Christine Riddell, Ms. Tracy Davis, Ms. Levine Kutter, Mr. Nzamo Dlamini, Mr. Omak Cullinan, and Mr. John Gerard Ingram Clark. In the interest of brevity, again, these parties are collectively referred to as the activists. Both matters before this court arose from three consolidated actions in the High Court, in terms of which the mining companies issued summons against the activists for defamation. The claims were based on the activists' critique of the mining companies' operations and activities in the Torman and Tolobeni mineral sands projects on various mediums and platforms. The mining companies sought several awards from the High Court against the activists for general damages in the sum of 14 million rand. In the High Court, the activists raised two special pleas. The first is the strategic litigation against public participation, or SLAPP, suit special plea, and the second is the corporate defamation special plea. The mining companies raised exceptions to both special pleas on the ground that they do not disclose a proper defense in law. Case CCT 66/21 was an appeal against the High Court's dismissal of the mining company's exception raised against the activist SLAPP suit defense special plea, where it held that the SLAPP suit defense special plea indeed discloses a proper defense to a claim for defamation. Case CCT 67/21 concerned an appeal against the High Court's upholding of the mining company's exception raised against the activist's corporate defamation special plea, where it was held that such a defense was not competent. These appeals arose from the same proceedings in the High Court and concerned much the same factual background, and so were consolidated for the purposes of hearing in this court. However, because they raise separate legal issues and debates, each appeal has been dealt with in separate judgments, both of which I am handing down today. Commencing then with the judgment in CCT 66/21 being the SLAPP suit's defense special plea. On the merits, the mining company submitted the SLAPP suit special pleas as pleaded by the activists in effect meant that the litigant could raise an abuse of process as a standalone defense to a substantive claim, and that ulterior motive alone, to the exclusion of the merits of the claim, could give rise to an abuse of process. The mining companies argued that such a position was inconsistent with the Supreme Court of Appeal's decision in MEC Department of Cooperative Governance and Judicial Affairs versus Mapanga. According to the mining companies, that case and similar cases placed clear, if not exclusive, emphasis on the merits of a claim in the determination of abuse of process. In the event that this court agreed with their exposition of the existing common law abuse of process, the mining companies resisted the development of the law to accommodate the defense as contended for by the activists. Mining companies did so on the primary basis that the activists had not demonstrated that the principles laid down in MEC for Health and Social Development Gauteng versus DZ on behalf of WZ that the development was warranted in the circumstances. Furthermore, the mining companies submitted that the common law principles of abuse of process are not, as the activists submit, inconsistent with Section 16 or Section 34 of the Constitution, nor the constitutional value system. In closing, the mining company submitted that the activists' SLAPP suit special pleas lacked the necessary averments to sustain the defense which they desired and raised. This was because the activists sought to have the merits of the claim excluded from the abuse of process analysis, contrary to that doctrine. The mining companies thus submitted that their exceptions in relation to the SLAPP special pleas suit to be upheld. The main thrust of the activists' argument was that the existing doctrine of abuse of process encompassed the SLAPP suit defense, and that the existing common law allows and requires courts to consider ulterior motive when assessing whether a litigant has abused court proceedings. The activists, relying inter alia on lawyers for human rights versus minister in the presidency, submitted that the common law also allows for ulterior motive on its own to be determinative of abuse of process in certain circumstances. In addition, the activists made extensive submissions as to why the mining company's strong reliance on the Mapanga was misplaced. According to the activists, the question of improper motive does not appear to have been at issue in Mapanga, and if Mapanga did indeed purport to hold that the motive or purpose of the litigation was irrelevant to the assessment of abuse of process, the activists submitted that that would be inconsistent with a series of decisions, including those of this court and the Supreme Court of Appeal. In the event that we differed with the activists on the provision of the existing common law, on the position of the existing common law, the activists argued that the existing common law then stood to be developed. The activists submitted, contrary to the submission made by the mining companies, that this case fell squarely within the principles laid down in DZ. As regards the SLAPP suit special pleas that they raised in the High Court, the activists submitted that the said special pleas were good in law, as litigation brought for an ulterior purpose is patently impermissible and constitutes an abuse of process. In a unanimous judgment penned by me, this court holds that the main issues in the matter, that is, whether the common law doctrine of abuse of process currently provides for the SLAPP suit defense, and if not, whether the law ought to be developed, fell within the extended and constitutional jurisdiction of the court. Furthermore, based in the main on the interests of justice criterion, this court holds that the order of the High Court was appealable. Furthermore, this court, in light of the issues that were before the High Court, concluded that the High Court's order dismissing the said exceptions constituted a decision on a constitutional matter for the purposes of Constitutional Court Rule 19. And as the issues were of general public importance and the matter was inextricably linked to the application brought under CCT 6721, which had to bypass the Supreme Court of Appeal on account of that court's decision in Media 24 Limited versus SA Taxi Securization Pty Limited, it was in the interest of justice to grant leave to appeal directly to this court. Now, before getting into the merits, it is appropriate to provide a brief discussion on the origin, nature, and development of SLAPP suits. SLAPP suits are generally described as cases without merit brought to discourage a party from pursuing or vindicating their rights, often with the intention not necessarily to win the case, but simply to waste the resources and time of the other party until they abandon their defense. The hallmark of a SLAPP suit is that it often, but not necessarily always, lacks merit, and it is brought with the goal of obtaining an economic or other advantage over a party by increasing the cost of litigation to the point that the party's case will be weakened or abandoned. A reading of the authorities makes it clear that both merit and motive played a role in the assessment of SLAPP's defense. The case before us requires this court to grapple with the place of SLAPP suit defenses under our law and to make a finding on the SLAPP special pleas raised by the activists. To do so requires us to remind ourselves of the SLAPP suit defense as pleaded by the activists. The defense raised by the activists was that the mining company's conduct in bringing the defamation action was A, an abuse of process, B, tantamount to the use of court processes to achieve improper end, that is, to use litigation to cause the defendant's financial and or other prejudice in order to silence them, and or C, violated the right to freedom of expression entrenched in Section 16 of the Constitution. Thus, distilled to its essence, the defense was really one of abuse of process. Now, there are a number of different categories of abuse of process in our law. The first type encompasses a situation where there is gross abuse of the procedure employed by a litigant, to the extent that the court, as a rare instance, will dismiss the claim without any regard to the merits. The second type concerns frivolous and vexatious litigation. In those cases, the merits of cases, both past and present, are germane in order to determine whether the court is being assailed by a further frivolous claim or something with arguable merits. The third type concerns criminal proceedings, public and private. The inquiry in those cases is whether the prosecution is being brought in the public interest and not to pursue some private objective. That is a question of the legality of the proceedings and the permissible statutory purpose for which the prosecution may be instituted. The question we must ask is whether there may be a further species of abuse case of the kind set out in the activist special pleas that falls within the inherent jurisdiction of courts to ensure that courts' processes are not abused. The determination of what constitutes abuse of process will always be fact-specific, and there can be no all-encompassing definition of it. A close examination of all the relevant circumstances must thus be made. In addition to the various types of abuse of process discussed above, this court is of the view that all else considered, there is another species of abuse not previously explicitly recognized that deserves the nomenclature abuse of process. That is the abuse that is the subject of the present matter. It is not hard to conceive such an abuse Hypothetically, a plaintiff would sue for defamation in circumstances where there are very little, if any, prospects of establishing a case for defamation. The defendant in that case would be in a position to show that the defamation action is being brought not to vindicate the plaintiff's right to a good name and reputation, but to silence the defendant or to burden the defendant in a manner that causes grave harm to the defendant's right of expression and the public interest that is being served by that expression, with the likelihood that pursuing the action will have that negative effect. In that instance, court processes are clearly not being used to resolve a genuine dispute, but are rather employed to achieve a result that undermines the rights in the Constitution. Such conduct could be labeled for present purposes abusive litigation. Generally, it would not be easy to establish a case of abusive litigation, but if one were able to do so, abusive litigation would have nothing to do with the right to access to courts in Section 34 of the Constitution. Instead, it would simply be about the use of court process and resultant legal costs as a means to an impermissible end likely to cause appreciable damage to fundamental rights. It would thus be about motive and consequence. Framed in the aforesaid manner, thus, abusive litigation would fall within the common law doctrine of abusive process, and it would consist of a consideration of both the merits of and the motive for bringing the case with its likely consequences. Courts, at common law and under Section 173 of the Constitution, have the power to prevent this type of abuse. The approach that we unanimously adopt here is consonant with the doctrine of abuse and process. Further, this approach can conceivably accommodate the SLAPP type of defense pleaded by the activists. So what bears consideration next are the activists' SLAPP special pleas. The activists' SLAPP special pleas, as pleaded, are predicated upon the proposition that the actions are brought for an ulterior purpose. This was based on the view held by the activists that improper motive alone was sufficient to warrant dismissal of the actions. Based inter alia on our conclusion on the position of SLAPP defenses under our law, this court holds that the activist's position is not sustainable. This court holds that the merits of the case also bear consideration when such defenses are raised. In the light of this finding, this court is of the view that the activist's special pleas lack the averments necessary to satisfy the requirements of the SLAPP suit defense as outlined. To this extent, the exceptions taken by the mining companies hold good and have to be upheld, and as a result, the appeal also has to be upheld. The activists are, however, to be afforded an opportunity to amend their special pleas if they so desire. As to costs, the mining companies have enjoyed success in that the special pleas have been found to be executable. But they have prevailed for reasons not relied upon in the exception. The activists have secured the recognition of the SLAPP suit defense, albeit not on the basis that they pleaded the defense or supported the defense in their submissions. Their success is nonetheless substantial, and they deserve part of their costs. In conclusion, then, and to summarize, this court holds that the SLAPP suit defense forms part of South African law, and the defense requires more than what the activists pleaded. This court also holds that the mining companies' exceptions hold good, as the activists' special pleas lack the necessary averments to make out SLAPP suit defense. As our law accommodates the SLAPP defense, there is no need to get into questions about the development of the law. It is for Parliament to consider whether a more comprehensive, specific SLAPP suit defense of the kind developed in Canada and the United States of America ought to be legislated. In the result, in the first case, that CCD 66/21, the following order is made. 1. Leave to appeal directly to this court is granted. 2. The appeal is upheld. 3. The order of the High Court is set aside and the following order is made. A. The plaintiff's exception to the first special plea of the defendants is upheld on the basis that the first special plea lacks the burdens necessary to establish the offence. B. The defendants are afforded 30 days from the date of this order to seek leave to amend their first special plea, failing which the first special plea is dismissed. And 4. The applicants are ordered to pay 60% of the respondents' costs in this court, including the costs of 2 counsel. Each party must pay its own costs in the High Court. Moving on then to the second judgment under CCT 67/21, being the corporate defamation special plea. As I've already mentioned, these appeals emanate from the same factual background and litigation history, and there is no need for me to repeat them here. Before this court, the activists submitted that the High Court erred in holding that a for-profit company may claim general damages in a defamation claim where the for-profit company does not allege or prove that A. the statements complained of are false, B. the false statements were made willfully, and C. that the for-profit company suffered patrimonial loss as a result thereof. They submitted that if the common law allows for-profit companies to succeed in a defamation claim for general damages without meeting these requirements, it is unconstitutional. But this position was abandoned at the hearing, and the activists only persisted with their alternative claim on the constitutionality of awarding general damages to trading corporations in defamation cases. In this alternative claim, the only claim pursued by the activists once the main claim was abandoned was that the activists submitted that the current common law position as set out in SA Taxi was incorrectly decided and that in accordance with sections 8.3 and 39.2 of the Constitution, the common law force to be developed to resolve this violation of the right to freedom of expression. This is so, submitted the activists, because allowing defamation claims for general damages imposes significant restrictions on the right to freedom of expression contained in the Constitution. This is constitutionally permissible in the case of plaintiffs who are natural persons and who bear the constitutional right to human dignity. They submitted that for-profit companies are not the bearers of the constitutional right to human dignity, and moreover, the interest of for-profit companies in their reputation is a purely financial interest. The activists argued that for-profit companies have no intrinsic value in need of protection. The mining companies, on the other hand, argued that the approach proposed by the activists would push the pendulum way too far against businesses operating as juristic persons and will make our country business unfriendly for both locals and potential investors from other countries. In essence, the mining companies argued that narrowly defined human dignity is not the only basis on which freedom of expression can be limited. Reputation or pharma similarly justifies the limitation of the right to freedom of expression. The activists appear to accept that for-profit companies have a reputation worthy of protection. The mining companies therefore submit that in light of the fact that a for-profit company has a reputation worthy of protection, it may claim general damages under a defamation claim. They went on to argue that the interest a for-profit company has in its reputation cannot always be vindicated by an action for special damages. The impact a company's reputation has on its bottom line may be intangible. It cannot always be measured in rands and cents. To permit companies to sue to vindicate their reputations only where they can prove financial loss will, in some instances, rob them of a remedy altogether. The mining companies further raise the public interest in protecting the viability of companies for the benefit of employees, consumers and shareholders, but also for the wider economic good. The mining companies therefore questioned the reliance on the narrowly defined human dignity by the activists. They questioned where this distinction could leave, for example, a charity-oriented non-profit company which has no financial interest but similarly no dignity. They similarly raised this point regarding small for-profit companies where the proprietor's reputation and self-worth may be bound up in the reputation of his company, for example, an attorney's practice. The first judgment, which is the majority judgment, penned by me, with Madlanga J, Matopo J, Nhlanhla J, Mlambo AJ, Theron J, and Tsikli J concurring, finds that this court's constitutional jurisdiction was plainly engaged as the matter concerns the balance to be struck between the right to freedom of expression in section 16 of the Constitution and the trading corporation's right to its reputation. In addition, the application raises important issues as to the development of common law in accordance with sections 8.3 and 39.2 of the Constitution. Furthermore, the questions posed in this application raise arguable points of law of general public importance, particularly concerning the two divergent judgments in SA Taxi as to the appropriateness of awarding general damages to trading corporations in defamation cases. Additionally, the ancillary question of the applicability of the right to human dignity to trading corporations bears consideration. On the question of granting leave to appeal directly to the Constitutional Court, this court finds that in light of the Supreme Court of Appeal having already decided the central question at issue in the case of SA Taxi, and that the Supreme Court of Appeal would be bound by its own decision, the interest of justice required the Constitutional Court to finally determine the matter. On the merits then, the first judgment sets out the current state of our law of defamation. In so doing, this court confirms the historical right of the trading corporation to sue for defamation under the Actium Injuriarum. Thereafter, it exposed the source of the trading corporation's right to reputation. In this vein, and following on from this court's jurisprudence in investigating directed serious economic offences versus Hyundai Motor Distributors Pty Limited, in the Ray Hyundai Motor Distributors Pty Limited versus Smith NO, and Tulip Diamonds FZE versus Minister of Justice and Constitutional Development, we hold that the trading corporation's reputational rights are sourced in the common law and not section 10 of the Constitution, which is headed human dignity. In this regard, this court finds the majority decision in SA Taxi to have been incorrect in finding that a corporate entity has a constitutional right to dignity. In sum, we find the majority judgment in SA Taxi to be wrong in its reasoning that undergirds the finding that the trading corporation has a claim for general damages in defamation based on the constitutional right to dignity. In concerning whether a trading corporation ought to be awarded general damages for defamation, this court recognizes that although a trading corporation has no feelings, dignity, or sense of self-worth which can be harmed, it has an objective external interest in its right to reputation and a good name. In reaching the conclusion that the awarding of general damages for the defamation of the trading corporation limits the right to freedom of expression in section 16 of the Constitution, we then consider whether such an award passes constitutional muster by way of section 36 analysis. The first judgment emphasizes the importance of the role of freedom of expression in a constitutional democracy such as South Africa. Thereafter, we point out that the importance of the purpose of the limitation is low, in light of the fact that the trading corporation's reputation rights are not sourced in the Constitution and are, at best, only enjoyed objectively. Regarding the nature and extent of the limitation, the first judgment concludes that awards of general damages for defamation, particularly in substantial amounts, tend to have a chilling effect on free speech. General damages, in contrast to alternative remedies like patrimonial damages, undoubtedly constitute a severe limitation on the right to freedom of expression. In considering the rational connection between the purpose and the limitation, we hold that our law has consistently justified general damages with respect to the dignity of a plaintiff as a means to assuage their sense of self-worth. There is only a very nebulous connection between the general damages defamation suit and protecting the trading corporation's bottom line. Importantly, the first judgment concludes that there are in any event less restrictive means available to achieve the vindication of a trading corporation's reputation, where the speech is of the nature that it is considered important for public participation, as opposed to the unjustified drastic restriction of the right to freedom of expression that an unqualified award for general damages entails. These less restrictive means include seeking an interdict, a declarator, a retraction, or an apology. Now, in light of this conclusion, the first judgment finds that the awarding of general damages must have regard to whether the defamation forms part of public discourse on issues of public interest. This is a pertinent factor that must bear consideration. Where the defamatory statements are made in the course of such public discourse on issues of legitimate public interest, general damages may not be considered. Where the defamation does not form part of the above-mentioned public discourse, the extent of general damages could axiomatically be determined on a fact-based approach from case to case. Imposing this qualification for the awarding of general damages would afford courts a discretion to weigh up the many different factual circumstances in which defamatory speech arises. Gratuitous defamation of a private corporation upon a matter of no public interest should generally justify compensation for non-patrimonial harm. Conversely, where there are issues of public interest, the award is not warranted because of the potential of suppressing important public debate in matters of public interest. Self-evidently, a court exercising a discretion in these instances would do so judicially with a weighing up of all relevant facts and factors. In sum then, the majority judgment conclude that the limitation is unjustified and absent the qualification proposed does not bear constitutional scrutiny in terms of section 36. In imposing this qualification, we will be giving recognition to the value of free speech on matters of public discourse of genuine public interest without doing so via a blanket exclusion of general damages to trading corporations. It is a less restrictive means of vindicating a juristic person's reputation. In the result, the court grants leave to appeal directly to this court. However, we dismiss the appeal and declare that save for where the speech forms part of public discourse on issues of public interest, and at the discretion of the court, trading corporations can claim general damages for defamation. Regarding costs, as both parties have attained some measure of success, there should be no order as to costs, as both are private parties engaged in this litigation. Turning to the second judgment, which is the minority judgment penned by my brother inter alter AJ, with Colin J concurring, that judgment disagrees with the first judgment in the following respects. First, that a trading corporation has no constitutional right to dignity. Second, that the award of general damages to a trading corporation is a severe limitation of the right to freedom of expression. And third, that the considerations in Section 36 of the Constitution do not clearly fail to justify the infringement to freedom of expression. On the first issue, the second judgment explains how the heading of Section 10 of the Constitution, that is human dignity, can be seen to create a textual obstacle and lead to an interpretation of human dignity as only referencing natural persons and excluding juristic persons. Such an approach would lead to an interpretation of Section 10 that is contrary to the general application of Section 8.4. However, even if a trading corporation is not entitled to the protection of its reputation under Section 10, a trading corporation still enjoys a common law right to protect its reputation. For this reason, it is unnecessary for the second judgment to make a dispositive interpretation on this score. With respect to the second issue, the second judgment finds that the common law has recognized general damages as a competent remedy for the unlawful defamation of a trading corporation. Therefore, it finds no basis for the first judgment's reasoning that an award of general damages to a trading corporation poses a danger to free speech that an award of damages for patrimonial loss does not. According to the second judgment, if at common law reputational harm may be compensated by an award of general damages, there was no reason why this should pose some special unjustifiable risk to freedom of expression at the instance of trading corporations that other remedies sought by trading corporations do not. The second judgment observes that it is actually damages awarded to trading corporations for patrimonial loss that may be sizable because of the commercial scale of the enterprise, the loss of profits that may result, and the ability to quantify such loss. On the other hand, awards of general damages to trading corporations are generally modest, reflecting the different compensatory basis. As to the third issue, the second judgment disagrees with the first judgment that a Section 36 analysis would not entail an inquiry into the constitutionality of the less restrictive means. In this respect, the second judgment finds that the first judgment failed to show that the supposed less restrictive alternative remedies to general damages were indeed less restrictive means to achieve the same purpose as an award of general damages. Furthermore, it is also not evident why the award of non-patrimonial damages at the instance of a trading corporation posed a distinct and special danger to freedom of speech. The second judgment further disagrees with the first judgment's findings that if general damages pose no greater deterrent to defamatory speech than any other remedies, then such damages serve no purpose and cannot be justified in terms of Section 36. It holds that such a finding failed to distinguish between purpose and effect. The second judgment explains that awarding general damages to a trading corporation has a legitimate purpose, namely the compensation of non-pecuniary loss by reason of reputational harm. This is a matter to be weighed in terms of Section 36 as to the importance of the purpose of compensation by way of general damages. The effect of an award of general damages upon free speech, on the other hand, is a different matter. These issues serve as an indication that the source of constitutional difficulty in this case was not to be found at the level of remedy, but rather the substantive consideration of what defamatory speech the Constitution may require a trading corporation to suffer in the interests of public debate. As a result, the second judgment finds that the first judgment proceeded from the unsubstantiated premise that the claim of a trading corporation to an award of general damages poses some special risk to freedom of expression that its claim to other remedies do not. Furthermore, it assumes that a trading corporation poses a greater risk to freedom of expression that natural persons did not. These assumptions held to the second judgment gave rise to the following anomalies. First, the first judgment considered there to be a constitutional principle that would incline against the award of general damages to a trading corporation where the defendant engaged upon public discourse for a legitimate purpose, but not to an unincorporated business. This amounts to presumptive exclusion and would incline to deny claims of general damages brought by a small incorporated family business, but not to an unincorporated firm of highly paid management consultants. It gives rise to arbitrariness that is contrary to the right to equal protection in terms of Section 9(1) of the Constitution. Second, it leads to the first judgment's untenable position that it is arbitrary to distinguish between different types of entities in awarding general damages, but it is justifiable to treat natural persons differently from all corporate entities. Under this principle of presumptive exclusion, natural persons who run businesses are treated differently from natural persons who do not run businesses. This approach would also exclude natural persons who undertake charitable work, but include a trust or not-for-profit company that does the same work. The second judgment then cautions that freedom of speech must be understood within the context of the real world of today that is dominated by social media platforms. These platforms are a great means by which freedom of speech may be exercised, but are also the greatest engine for falsity. It then follows that the right of a trading corporation to protect its reputation matters, and the common law's protection of that right must be carefully weighed. Ultimately, the second judgment finds that the right to freedom of expression cannot be cast as a higher order right without more. Its status as a constitutional right does not avoid the many complexities as to when the right is engaged and how strongly it counts. According to the second judgment, false speech and sometimes also hateful speech that harms another's reputation counts for little in the recognition that is due to freedom of expression, and it is sometimes not protected speech to which a person may claim an unqualified right to freedom of expression. For these reasons, then, the second judgment holds that no case has been made out to show that the claim of an unlawfully defined trading corporation to an award of general damages was constitutionally excluded, whether presumptively or otherwise. In the result, the second judgment would have dismissed the appeal with costs, including the costs of 2 counts. The following order is made. 1. Leave to appeal directly to this court is granted. 2. The appeal is dismissed. 3. It is declared that, save for where the speech forms part of public discourse on issues of public interest and at the discretion of the court, trading corporations can claim general damages for defamation. I hand down the judgments.
Right.